From the Library of Congress in Washington, D.C.
Good morning, everyone. I think we're about ready to get started. Welcome to the second day of our roundtables for the Copyright Office's study on Section 1201. Before we begin, I just would like to go over a few logistical items. Apologies to those of you who heard this yesterday. But first of all, my name is Kevin Amer. I'm a senior counsel in the Office of Policy and International Affairs here at the Copyright Office. The roundtable sessions will be moderated by us here at the table. We will pose questions to begin the discussion on particular topics. As most of you know, we ask that to indicate that you'd like to be called on, if you could please turn your name placard vertically. Just given the number of panelists and topics, we ask that, if possible, you could try to confine your comments to about 2 to 3 minutes. We apologize in advance if we have to cut you off, but you know, we appreciate your understanding on that. We also ask that you please obviously focus your comments on the specific topics that were raised in our notice of inquiry and that are asked in our questions. And finally, just at the end of your comment, if you could please turn off your microphone because it avoids interference with the sound recording. Our final session of the day is an audience participation session, and time permitting, additional comments from the participants. For the audience, there will be a sign-up sheet, and again, we ask that comments made in that session be limited to 2 minutes. In addition, as you can see, today's event is being video recorded by the Library of Congress. Participants, we provided you with a video release form. If you haven't yet signed it, please do so and return it to any one of us here at the table. For audience members participating in the last session, if you do decide to participate, you will be giving us permission to include your questions or comments in any future webcasts and broadcasts of this event. In addition, as you can see, we do have a court reporter transcribing the proceedings. Finally, we just would like to note that we may seek additional written comments in response to issues that may come up during the roundtables. If we do so, we will issue a formal Federal Register notice as previously. At this time, I would just like to ask everyone in the audience to please turn off or mute any devices that might interfere with the recording. Does anyone have any questions about logistics before we get started? Okay, great. Before we begin, I'd just like to invite my office colleagues to introduce themselves.
Andrew Moore, I'm a Ringer Fellow at the Copyright Office.
Jason Sloan, I'm an attorney advisor in the General Counsel's Office.
Reagan Smith, Associate General Counsel.
And so before we begin, I'd like to invite the panelists to just go around quickly and state your name and affiliation.
Alan Adler, I'm with the Association of American Publishers.
June Bessick, I'm the Executive Director of the Kernigan Center for Law, Media, and the Arts at Columbia Law School.
Brandon Butler, I'm the Director of Information Policy at the University of Virginia Library.
Seth Greenstein from the law firm of Constantine Cannon. I'm here today as the aftermarket replacement part for Aaron Lowe of the Auto Care Association.
Keith Kuberschmidt, CEO of the Copyright Alliance.
Jamie Love, Knowledge College International.
David Perry from the law firm Blank Rome in Philadelphia on behalf of Dorman Products, which is an aftermarket auto parts company.
Ben Scheffner, Vice President, Legal Affairs at the Motion Picture Association of America.
Robert Schwartz, Constantine Cannon. I'm counsel to Consumer Technology Association.
Bruce Turnbull, counsel to the DVD Copy Control Association and the Advanced Access Content System Licensing Administrator, LLC.
Great, thank you. So this panel, as you know, involves the anti-trafficking provisions of Section 1201. And to kick things off, I'm going to turn it over to Reagan with a few introductory remarks.
Yeah, so the anti-trafficking prohibitions of Section 1201 are not part of the triennial rulemaking, as I think you know, but they are generally prohibitions upon both access controls and Section 1201B, which applies to copy controls. In many of the comments we received, we heard arguments that the intended beneficiaries of exemptions to the prohibition on circumvention are difficult for the intended beneficiaries to engage in without assistance from third parties. And the most recent rulemaking, the Register of Copyrights recommended to the librarian some of the difficulties that have arisen with the anti-trafficking prohibitions. She stated, Congress may wish to consider clarifications to Section 1201 to ensure that the beneficiaries of exemptions are able to take full advantage of them even if they need assistance from third parties. While the anti-trafficking provisions can curtail bad actors seeking to profit from circumvention by others, they also constrain the ability that allows third parties to offer assistance to exempted users. So as the first question to kick off, I think, rather broadly, is how effective are the participants feeling that the provisions are, the anti-trafficking provisions have been at encouraging the innovative digital distribution models and deterring infringements? Mr. Turnbull?
In both the DVD and Blu-ray case, and now hopefully in the Ultra HD Blu-ray case, the availability of the content protection systems, the technological protection measures, CSS and AACS, and now AACS2, were essential to the development of those markets. And the anti-trafficking provisions have been essential to the integrity of the licensing of those technologies. Both DVD-CCA and AACS have taken advantage of the anti-trafficking provisions in court cases against entities that are distributing trafficking in circumvention products. They are absolutely essential to the business of both of my clients and to the development of the market, where consumers have enjoyed tremendous new ways of enjoying the content in the digital era.
Thank you. Mr. Adler?
For the publishing industry, the importance of the anti-trafficking provision can't be overstated. The fact of the matter is, again, we're dealing with a situation where we're talking about circumvention of technological protection measures that don't involve all the complications of dealing with software that has a separate functionality besides the fact that it is serving as a gate, essentially, for authentication of who has access to the works. So if you think about the way the explosion in online subscription services for journals, ebooks, a variety of other content have taken place, it's all taken place because of the ability to have that kind of arrangement where authorized and authenticated access is done by passwords generally, and those passwords can't be circumvented, at least to the extent that there's not wide availability of the kinds of tools or devices or services that would proliferate and basically threaten that type of model.
Can you elaborate for a second on the role of the law there in encouraging these models and protecting the password, as opposed to just the fact that there is a password on it? Do you have to undertake enforcement activities, or do you think it is just a broader deterrent effect?
Again, as I said yesterday, I don't think the law had the expectation when Congress enacted it that it was going to really be able to prevent or even deter hackers as such. What it was designed to do, as most laws are, is to make sure that law-abiding people remain law-abiding. And so the notion that you could have some kind of locks that you're permitted to use, you're not required to use them, but you're permitted to use them without having legal protections against people constantly trying and succeeding ultimately in circumventing those locks, would mean that the locks themselves would be ultimately ineffectual. So the law is very important as a general matter, not because it deters or prevents the hackers who are determined to engage in illegal activity, but it generally means that people who are law-abiding citizens will respect the business model and will participate use of that business model, understanding why they need to have their authorizations authenticated.
Thank you. I think Mr. Cooperschmidt's next.
Yeah, thank you. It's pretty clear, I think, that consumers in the United States, as well as large and small copyright owners, have benefited from this sort of explosion of innovation. And this explosion of innovation that we see is due, at least in part, because of the protection provided in Section 1201 and the anti-trafficking provisions. Those anti-trafficking provisions have been a very, very important part of 1201 since the very beginning. It's our belief that they shouldn't be cut back on at this point. I mean, as Alan mentioned, the ultimate purpose is to keep sort of this hacking software out of the mainstream and limit its availability to the fringes, so you can't just walk into Best Buy, for instance, and get a copy. But there are many other benefits. It prevents tracking in circumvention technologies. By doing that, it reduces the attractiveness of commercial business models that are based on enabling access to infringing works. Being able to target trafficking is also important because actions of distributors that circumvent distributors of these circumvention technologies is comparatively, I repeat, comparatively easy to detect. And targeting them is the most efficient and effective way to actually enforce 1201. And then it also helps prevent this sort of capital formation around the black box business dedicated to circumvention of sales of circumvention devices, and prevent sort of this arms race, if you will, where a technology is cracked and the black boxes are out there, and so you have to create a new technology. And I think that's the benefit of everyone. And just lastly, just to repeat, is what Alan said. It ultimately keeps consumers honest, if you will, preventing circumvention tools from being conveniently available at Best Buy, Amazon, Newegg, and things like that. That's the underlying purpose, and I think a lot of people will agree with me in that it has served that purpose and served that purpose well, and is in large part responsible for this tremendous boom in innovation that we have today, and these new business models that consumers have access to, movies and music and all sorts of copyrighted works.
Thank you. Mr. Lev, would you agree with that characterization? Do you have a different take? If you can turn your microphone on and speak into it.
No.
Oh, okay. Well, you had your placard up, so I didn't know if you had another thought you wanted to share.
I do, yes. I mean, there's a wide range of areas where the public interest in having companies protect their works through technical measures are appropriate. But I think as the evidence in this proceeding has shown, and in other proceedings has shown, there's a whole set of areas where it doesn't work out well. It has perhaps like an anti-competitive effect, or it defeats people from being able to use lawful exceptions and things like that. So I think that the task for this group going forward is to figure out how do you address the fact that the law covers a lot of stuff and not everything is exactly the same in terms of the way things play out. To us, part of it's what obligations do you put on people? Part of the answer is what obligations do you put on people that expect legal protection for their technical measures? In other words, can you just do anything and expect to be protected with the full weight of all the laws coming down on your head if you violate anything, no matter what the context or circumstances is? Or do you have any obligation to address some of the other issues that may come up? That many of which are raised in the proceedings. So part of it's that, and part of it is, do you have the same rules for every sector of the economy? Is it the same thing for movies as it is for auto parts, for example, which will be discussed here? Is it the same thing for textbooks as it is for computer games and things? And I think that it's a mistake to have a unitary system where everything is kind of thrown together. So I think part of the way forward is to recognize that not all uses of goods present the same problems. Part of the solution is to realize that there should be some affirmative obligations on people that expect legal protection and the state to help enforce their technical protection measures, to address public interest in areas. And I think the other area is it may be that there's a more of a realm for a category of people that are authorized to use circumvention devices under certain contexts. For example, in the area for blind people, it's great that blind people have the right to circumvent, but I mean, it's not something that all blind people can do without depending on someone to provide a service for them. Same thing, I'm sure, as for people that want to, fix their own cars or something like that. Not everybody can do these things on their own, and but it may be that you in some areas you may feel like you want to have some, not completely open the door all the way, but you may want to have some sense that the people that are authorized to provide services like that are somehow more accountable and following some more circumspect things. And so I think just in terms of opening things, that's what I wanted to say.
Okay, thank you. So that raised a lot of issues, some of which we'll unpack as we go throughout the discussion. But one follow-up question for you before I let Ms. Besic speak is, yesterday in our first panel, as well as the Copyrights Office study on embedded software devices, which was the roundtables 2 days ago, we talked about whether there's a way to sort of divide the line between software and embedded devices, perhaps not related to the distribution of expressive content, such as a garage door opener, a car, versus the consumption of books, movies, music. It sounds like you think some line on that might be relevant to the anti-trafficking laws? And would you support, are you suggesting statutory reform?
Well, I think statutory reform should always be considered, and we would support statutory reform. But whether you do it within the discretion you have through rulemaking or whether you do it through statutory reform, I think these distinctions should be followed. I also think you can make distinctions between content such as entertainment products, such as movies or computer games, from material that's used in an educational context. It just is another illustration of an additional distinction you can make.
Thank you, Ms. Besic. Excuse me.
It didn't go all the way. So I guess I'm not as certain as Mr. Love is about how you can make these discriminations between content, because I think that educators and librarians would say that movies and other kinds of works are very relevant, music and things like that. So I think one of the difficulties that we all face is how to draw lines. For example, I am sympathetic to the notion that technological protection that protects functional works might be in a different category. However, how do you distinguish between computer software that runs a particular function, car, or whatever, and the fact that there's still may be a lot of protectable expression in that computer program, and we have to make distinctions somehow. The other point I wanted to make originally was that there were a number of comments to the effect that the system isn't working anyway, so why should people be concerned about, anti-trafficking exceptions or other exemptions? And I would say that a lot of this isn't a black or white, an either or. You can't argue that a system isn't effective just because some people can bypass. There's always been some degree of infringement. There always will be. The real goal is to reduce it to the level where you still have a viable market. So that, I think that goes back to Keith's comment about, you don't want it, just available at Best Buy. Well, you don't want it just available. I was thinking of Walmart, actually, Keith, the same idea. And so it's really important that that material not be, the circumvention means not be so generally available.
So you would agree, you keep it out of Walmart, Best Buy, sort of the easy access for the law-abiding citizens, and the hackers can find things in the dark corners, and that's not proof that it's not working.
Right.
Just to sort of follow up on that, and I think this picks up on something that Mr. Love said. We had a lot of comments drawing the distinction between devices, circumvention devices, and services. And there was a lot of concern expressed about the need for beneficiaries of exemptions to use or to seek assistance from third parties in order for the exemptions to have any practical effect. I wonder, just from your experience, to what extent is that a concern? Have you seen that out in the marketplace? And if so, to what extent should the law recognize that sort of distinction, and what would you suggest could be done about it? I believe Mr. Adler was next. I know you may have had a comment about the previous question, but feel free to address this as well.
Yeah, I think that the real problem here is it's not so much distinguishing between the levels of protection for different types of works. I mean, the issue of dealing with embedded software in consumer products and the functionality issue with respect to driving those products, again, should not become the tail that wags the anti-circumvention dog, because the issue for anti-circumvention was primarily about protecting access to expressive works. And the problem with that is, in response to what Jamie suggested, is simply that there's no way to allow for the dissemination of tools that only enable the exercise of exemptions or other kinds of authorized circumventions. Let me give you an analogy when we talk about third-party assistance. In most jurisdictions, if you want to go into business as a locksmith, or if you want to seek employment as a locksmith, you have to be bonded, you have to be certified, you have to be licensed, and the tools that you're able to acquire are very carefully regulated and tracked. And those are mechanical tools, very distinctive types of tools. What we're talking about in the online world, when we're talking about circumventing various types of technological protection measures, we're primarily talking about software acting on software. Or we're talking about things like random number generators that are going to try to find the proper password or the combination for the authentication key that allows somebody to access the works. And it's clear that those types of things are going to have many legitimate uses, as well as they're going to have these types of illegitimate uses. And it seems that it's going to be extremely difficult to be able to identify them, to be able to regulate them, to be able to ensure that the people who would be authorized to use them to perform circumventions are in fact also properly regulated.
Thank you. Mr. Greenstein?
Thank you. So there are a few issues here I'd like to address from the past few questions. So I appreciated Mr. Adler trying to draw the distinction between, access to expressive works versus trying to get access to the functional aspects of the work, or the aspects of software that control function and have no other purpose. And I think that really is a line that is easy to draw. I mean, where the software interoperates with the part, controls the part, and is really part of the part. It's inseparable from the part. I think what we're talking about, the ability to circumvent a technological protection measure to get access to the work, is really all about repairing the functionality, augmenting the functionality, customizing the functionality, and not anything having to do with the expressiveness of the work. Some of the software, in fact, may not be copyrightable at all. There is one case in the Ford versus Autel where the court basically found this is not copyrightable. The elements that you're trying to get access to are not copyrightable. And the same was true in the Lexmark versus Static Control Components case, where they found the software was not protectable by copyright. So that's one issue. Looking at the real object of protection here, the real object of protection is not the expressive nature of the software code. The real object of protection is the functionality provided and stopping others from repairing that functionality, stopping competition in the repair of consumer products. And that being the case, I mean, it's really an interesting question as to whether Section 1201A actually applies, or A1 or A2 really applies, because the consumer owns the work, owns the product, and has the right of access to all the functionality provided by the product. So is there really an issue with access? The consumer has authorized access to the functionality provided by the software, and that is the only purpose of the software. So I would say a good argument could be made that there's no 1201 A1 or A2 issue to begin with, and the same would be true for B. Lastly, I do want to address one of the points that you raised with respect to the difference between devices and services. I think you cannot make that distinction, particularly for the auto repair industry, simply because not every mom and pop shop, repair shop, is going to have the ability to develop the software that circumvents, that is able to then repair the software in the car. But everyone should be able to use a tool that is provided by someone else, developed by somebody else, that enables that repair, which is why I think you cannot really make the divide based on devices versus services. I think the divide really has to be between protection of functionality versus protection of expression.
Thank you. I wanted to ask a question that sort of ties what you've said to what Mr. Adler just said. Mr. Adler mentioned that it would be difficult to limit any exemption to assistance for a permitted exemption, and you're saying there's sometimes trouble taking advantage of the exemption on behalf of the intended beneficiaries. So my question is, to what extent have the intended beneficiaries of the office's exemptions relied on tools or services that would be subject to the anti-trafficking prohibition? So I guess, getting something maybe in a way they're not supposed to be. And on the flip side, how much are they prevented from being able to make use of the exemptions? So Mr. Schwartz?
Well, you started off by observing that that anti-trafficking really isn't implicated in 1201A1, and I think that kind of answers the question. I'd like to quote somebody, and it was in our comments, quote, "In our view, manufacturers, consumers, retailers, and servicers should not be prevented from correcting an interoperability problem resulting from a protection measure causing one or more devices in the home or in a business to fail to interoperate with other technologies." That was Chairman Bliley of the House Commerce Committee at the time on August 8th, 1998. In his floor statement, I think he would have included autos if one had envisioned the importance of functional software at the time. So I think the answer is simply leave trafficking to the courts where it belongs, and where I know Mr. Turnbull has been very interested in those things. When it comes to the question of the office's role and the NTIA's role in exemptions, I think honestly the NTIA had it right and the office didn't. There should be a presumption at the very least that somebody is entitled to service, however the service is provided, whether strictly as a service or taking advantage, or the servicer taking advantage of a device, when it comes to the exemption process. And I would say that when the question is interoperability and functionality, that the presumption should be conclusive. I'm not here to talk about the expressive end of that. CTA may have a range of views on that, but CTA was extremely concerned with the outcome of the proceeding with respect to autos, and also with the reference to the Unlocking Act. Again, to refer to what everybody knows about the tools being widely available to people. When the office processed the previous exemption and the Congress considered the Unlocking Act, everybody knew that unlocking a cell phone required some type of expert assistance. And it didn't seem to trouble the office in the past when it granted the exemption. The Congress acknowledged that in legislative debate. I don't think anybody contemplated that the fact that Congress said, oh yeah, you're entitled to expert assistance in the context of cell phones meant you couldn't have it when it came to autos. I've used up too much of my time.
And just to follow up, just to clarify, so when you talk about a presumption that third-party assistance should be allowed to make use of an exemption, is that your understanding of current law, or is that a change that you would like to see? And is there any relevance to the fact that in the Unlocking Act, Congress expressly provided for third-party assistance? Does that speak to what current law may or may not provide?
The answers are both and no. I think CTA's comments argued by quoting this legislative history and others that there was no intention for an exemption for third-party assistance to be unavailable in the exemption context, so long as it didn't affect the legal environment with respect to trafficking. If CTA would be in favor of clarifying the law in this regard, has so advised the House Judiciary Committee, and as one who, on behalf of a cell phone reseller, was involved as a stakeholder in legislative discussions, I don't think anybody had in mind that this would be cited by the Copyright Office, the Register, as a reason to, the first time the subject came up at all, to say, oh no, you're not entitled to third-party assistance.
Mr. Scheffner, do you have a view on Mr. Schwartz's interpretation?
Sure, I'll get to that in a second. Let me just back up for a second. First of all, I just want to attach myself to and endorse the previous comments of Mr. Turnbull, Mr. Adler, and Mr. Cooperschmidt about the importance of the anti-trafficking provisions to the success of the motion picture industry, various business models over the last 15 years, from DVDs and Blu-rays to all of the explosion of now 115 legal online services here in the U.S., over 400 worldwide, virtually all of which incorporate technological protection measures, of course, with the backstop of Section 1201, both the anti-circumvention provisions and the anti-trafficking provisions. But getting to your question from a minute ago, specifically about whether the prohibitions on trafficking in anti-circumvention devices and services have impeded people's ability to exercise the exemptions that they've been granted through the triennial rulemaking. And I think the answer is no. I think if you go and look back at the record established during those 6 rulemakings now, as well as the record developed through these proceedings here, you don't have people coming forward and saying, you know what, the Copyright Office told me it's okay to do X, Y, and Z under this exemption. However, I'm not able to do it because of the anti-trafficking provisions, at least in the audiovisual sector, which
Yeah,
I'm
I was going to ask,
about.
do you have an opinion about the auto industry, or would you just treat that as, not in your sphere?
I'm going to stay focused for the moment on our own industry. As Mr. Adler and Mr. Cooperschmidt alluded to, we know that there are anti-circumvention software available out there. It's not, importantly, on the shelf at Best Buy, et cetera, et cetera. And we think that's an important distinction. If it were on the shelf at Best Buy, or you could go to Amazon or Newegg and click it, it would essentially send a message to the public that, hey, it's okay as a general matter to use anti-circumvention software, which it's not. Again, we acknowledge that there is nonetheless such software out there. And again, I don't think there is evidence established by the record of either the triennial rulemakings or in this proceeding that shows that those people who have been sort of granted exemptions are nonetheless not able to take advantage of those exemptions due to the prohibition on trafficking and circumvention of devices and services.
Thank you. Mr. Butler, you've represented people who have, petitioned for an exemption. Do you have a viewpoint on that?
Yes, absolutely. So a few things to say. So one is a key reason that none of the folks that I work with in the past and now have been terribly deterred yet by anti-trafficking is that we're free riding on the pirates, right? I mean, Handbrake is there, it's easy to find, and so if you want to rip a DVD, it's easy to do because luckily the things we want to rip are also things that pirates want to rip, right? And so we get to, it's just...
You don't need it to be at Best Buy.
You don't need it to be at Best Buy, right? It's easily, you just Google it. And so, sorry Google. So, I'll be quoted on that, I'm sorry. But the problem I think that I see going forward is that we are, like at University of Virginia, for example, we're really interested in investing heavily in digital preservation. And we're building special collections of digital archives. So we have Salman Rushdie's laptop and everything that was on it. Some of that stuff is in proprietary formats. I foresee that as DRM ages, it will, more and more different formats will become obsolete, and we'll be asking for exemptions to crack things that no one cares about but us, right? And so the pirates are not going to make emulators for obscure 1980s, DRM software. And so what are we going to do in that context? I think we have to be a little bit forward thinking about that. And even if, right, we build some internal expertise, and so some archivist we have very talented archivists who could build that tool, can they share it across consortia? That's generally the way these things work. So that's one worry that I have, is we've been free writing on pirates because we've only asked for DVDs, but in the future, what will we do when we're asking for more and more obscure formats? And then another thing, did you have a follow-up question about that?
Yeah, I guess, so if you're suggesting if you develop an archivist, you can create this tool and then shares it with another archivist, that would implicate 1201B in trafficking in technology product or service? I mean, is that what you're saying? Do you have a fear?
That's what I would fear, right? That there would be some uncertainty about that, or that another way that libraries frequently work. Universities, there are of course many vendors who are experts, who are external to the university, who develop specialized products and services only for libraries, only for universities. And it may be that they might develop the better tool than we did, and an exemption might empower them to do that. So that would certainly be, right? I mean, so maybe the archivist working inside could make it, and maybe they could share it, but certainly, a specialized vendor couldn't say, hey, we've got a way to facilitate digital preservation.
Right, but so if the exemption process were to extend to sort of encouraging this market for circumvention tools, I mean, would that bleed into some of the other concerns we opened up, and to encourage your vendors to market and sell these tools? It seems like might implicate what others have said.
Well, I think not. I think there's security built into the whole reason that we would be coming to the table, which is no one else cares. And so Best Buy would not want to buy, Windows 98, proprietary file format emulators. And so there's just the consumers don't care. I think no one at this table would actually care. They wouldn't be harmed. And so as is often the case, it would sort of only be the conscientious folks who are trying to do their jobs who would be deterred in that context.
Ms. Bessick, did you want to respond? I just wanted to say sorry, the microphone.
There was an earlier comment about whether the Copyright Office has the power to do certain things under regulations, or whether it would have to be an amendment to the law. And I don't think you can really argue that things like permitting anti-trafficking or circumvention services are currently embraced within the law. I mean, there are specific places where it's permitted in Section 1201 and elsewhere, encryption research and I think reverse engineering, where there's, is that? For interoperability. I think they're and law enforcement. But I think that in general, the way the statute is structured, there really is no good argument that you can do that now. That's not to say that the law couldn't be amended, and we're talking here about whether that's a good idea or not, but I don't think it can just be done right now through regulation.
Thank you. Mr. Perry, you've had your placard up for a while.
Well, not surprisingly, I guess I would echo a lot of what Mr. Greenstein was saying. Even this discussion so far today, I think, illustrates that not all software is created equal, that maybe the expressive versus the functionality divide is something that really needs to be focused on. And maybe it's easier when you're in the automotive realm. Maybe that's an easier case because not everybody. I think a lot of people can appreciate that a lot of the software that's in your car is not expressive. It's functional. It's literally under the hood. And in fact, it's all over your car. It's hidden to everybody. And, whether there will be litigation to bear out that software that now serves what was once a purely electromechanical function does not enjoy protection at all, that may happen. It may happen in litigation, which of course is very costly. We, our client, an aftermarket auto parts company, a large company in that space, was watching, with a lot of interest how the exemption was going to come out, if it was going to come out, and how it would be worded. And so, I think it's worth noting that if you look at the proposed Class 21 exemption and you compare it with how it came out in the end, the proposed class included wording, buyer on behalf of the lawful owner. We were very interested in that wording. Our client does a lot of work on behalf of owners. Virtually no one in this room probably could fix most of their car by themselves anymore. And if you look at the final class exemption, it now says by the authorized owner. So our client and many others in the aftermarket space, I think, looked at that and said, we still don't have the clarity that we need to do what we do, which is a hundreds of billions of dollars industry. And I think everyone who has a car, if they haven't gone to your local mechanic yet and been told that there's something that they just simply can't fix because of the complexity in the software, that's going to happen, and it's increasingly occurring. And so, as Mr. Greenstein said, there is a competitive or anti-competitive aspect to this that has to be addressed, and there needs to be a way that the aftermarket, whether it's automotive or others, can deal with software. And I know that's sort of embedded software, which was dealt with separately, but the expressive and the functional, that's a pretty important line.
To that point, are there any sort of lessons in that respect that we can draw from the Unlocking Act? I mean, has there been an increase in sort of services that content owners might find objectionable as a result of the third-party assistance being provided for? Please.
No.
Anyone else want to? Well, Mr. Love, you can respond to that or to the previous question.
Alan Adler brought up the issue of regulation of locksmiths. I think that's something that people probably should take a harder look at. I don't think locksmiths are really regulated everywhere, but I think that in some states they definitely are. And I think the idea that you'd have people that have access to tools that are not generally available, and that in some cases they're posting bonds, are the authorities aware of who they are, they have certain responsibilities, and that they're reputable citizens is sort of makes a lot of sense in that particular area. And it may make sense in this area in terms of the things. I mean, you could imagine a situation where libraries develop their own standards for sort of a self-regulatory type proposal where they could sort of imagine practices that were reasonable and limited to the purposes to which they're authorized to use works under exceptions, and where that could flourish. I think the problem is you had this lobbying from the motion picture industry, the database industry, a few sectors of the economy, maybe people with operating software, that were commercial products, mass market type products for DRM protection, and back in 1996 and things like that. And then you have these laws that just sweep everything into it. And I think that what would have been better is if sectors that felt that they deserved to have the state intervene and make things illegal would themselves make the case that motion pictures deserve some kind of protection, or maybe other types of works do, as opposed to just starting with the assumption that everyone automatically, no matter what the context is, basically gets it. So I think you should have to make the case that the state should have to intervene. And in terms of the cost of some of these systems, in terms of managing the cost of differentiation, I think it would be reasonable that the people seeking the state to provide the legal protection could pay money to share some of the cost of administering these systems, which are extensive, and that the people that are seeking to operate as providing services, they could also bear some of the cost as well. I mean, that could be kind of approach, you might look in some of the others. The other thing I'd like to call attention to is that the EFF submitted on April 21st, 2016, in the Food and Drug Administration, they submitted comments on management of cybersecurity in medical devices, and they described, I think, are quite important, some of the growth of security interest and problems that you have in medical devices that are implanted in your body, which could kill you. And you know, where these issues of DMC protection come up. It's just an example of how far out you're going to have, as other panels have talked about, in refrigerators and, you know, operating your lights, everything about your home. It's increasingly becoming, you know, we're enveloped in a system of artificial intelligence, of people doing everything you can possibly imagine, automatically driving cars, managing I spent $825 yesterday on getting a pollution control device in my car. It's probably an aftermarket part. I'll have to check. I think that you've got this sort of bad model for regulating much more than what people anticipated 20 years ago. And I think that you just have to sort of get back and take a different approach. You should have to prove that you get the benefits of the technical protection from the government, not just assume that it's there and then you have to work backwards.
Thank you. I think Mr. Turnbull was next.
I wanted to make a couple of points. One, well, we have no opinion on the sort of things that are clearly distinct. I mean, the auto parts sector. The concern that we do have is in drawing the line between functional and expressive. You could unintentionally sort of go too far the other way, if you will, and that is that in a DVD player or a Blu-ray player, what plays the content is a computer program. And it is subject to certain requirements under our licensing agreements that require that it be robust against attack in and of itself. What AACS and DVD-CCA provide are specifications for how those individual programs would be developed. And so if you simply draw the line and say, well, the content itself, the expressive work on that's encrypted on the Blu-ray is protected, but the computer program that plays it is not, that has the effect of defeating our system. And we would be very concerned about that. And so I think in drawing whatever lines anybody's going to draw, that I think needs to be very carefully preserved. That the functionality that actually enables the playback of the expressive content needs to be protected as well. The other point I wanted to make is that something that both DVD-CCA and AACS-LA have offered and has never been taken up on is for people who are interested in various exemptions or various functionalities that are the subject of exemption requests periodically, ought to come talk to us about ways in which this could be done voluntarily and through tools that we could cooperatively develop and could be licensed and agreed to by the technology providers. And you know, we've periodically made efforts to do some on our own, but we would certainly be open to cooperative efforts.
Are you suggesting you could, you know, license some sort of a tool that would allow, that would otherwise be implicated by 1201B?
Yes. Well, it wouldn't. I mean, it wouldn't be implicated by 1201B because it would be licensed. But for example, a number of the exemptions have had to do with short portions of films that are on DVD or Blu-ray. There could be a tool that could be developed that would enable that specifically and wouldn't have people using tools that are copying the entire movie. And there are various kinds of ways that could be done. You know, I'm not saying that it would be easy or simple, but there are ways that I think that working together, those kinds of things could be developed, and then they could be presented as part of an exemption if that was, you know, important aspect
Making it
of it.
harder for Mr. Butler to get handbrake, maybe.
Yes. Yeah.
Okay.
Yeah. Yeah.
Okay, I want to steer the conversation a little bit back to Kevin's earlier question, which was can we learn from the Unlocking Act? And I noticed Mr. Perry said the proposed Class 21 was for an exemption for the auto industry, auto repair, for actions by or on behalf of an owner. The Unlocking Act, that language said that circumvention in the case of unlocking cell phones may be initiated by the owner of any such device or by another person at the direction of the owner. So I'm wondering, we can both think big in terms of perhaps there's actions that would require some sort of statutory reform, but what are people's opinions on whether the triennial rulemaking process should extend to language such as that? Is there a risk? Is there a benefit? Mr. Adler?
Yeah, I think we should be very careful. We need to be very careful about generalizing or extrapolating broadly from what Congress was doing with respect to that legislation. And the reason is because the legislation was passed only after Congress had satisfied itself that by permitting such third-party assistance, they were not threatening anyone's copyrighted works. Representative of that, this is a statement from the House Judiciary Committee report. It says, circumvention for unlocking does not compromise the security of the information on the phone, and it does not expose any copyrighted works present on the phone to increased risk of infringement. Legalization of circumvention that has such harmful effects is not the intent of this legislation, and it would not be authorized by its provisions. The Senate Judiciary Committee said the same thing in its report. So they set a pretty high bar by determining before they acted that what they were authorizing was not, in fact, going to threaten infringement of any copyrighted work.
Could I just ask, so what sort of evidence would be useful or relevant to making that sort of determination? I mean, would we look to sort of the prevalence of claims that are targeting services rather than devices? I mean, in sort of evaluating whether permitting third-party assistance would threaten a particular market.
Over time, we would be looking at those kinds of claims. We would see ultimately whether or not there would be instances where allegations of infringement resulting from circumvention could be traced back to what had been authorized by the legislation. I think what Congress did in this instance, and what anybody would have to do in being a proponent of such third-party assistance, is to actually think through, in fact, what is being circumvented and what are the consequences of that specific circumvention. That's what Congress did. And it was precisely because it determined that that authorized circumvention, done even by third parties, would not allow them to expose any copyrighted works to infringement, was the reason that Congress felt comfortable authorizing that.
So would that be an argument for allowing the Copyright Office to make a similar assessment within the rulemaking, or?
No, quite the contrary. I think that this is a task that only Congress should be permitted to do because it is so significant in terms of its potential implications. And I think it's not something that can simply be delegated to either the Register or the librarian. And if I may just add one other thought in response to what my friend Brandon said before, I mean, we're very sympathetic to the whole notion about libraries, archives, academic institutions wanting to preserve the works that are produced by the people in my industry and others. But there is another avenue for them to pursue that. As the Copyright Office well knows, a few years ago, there was a very comprehensive study done of Section 108 of the Copyright Act, which specifically would have allowed for addressing questions about digital preservation, including preservation of works that only exist in digital form. And we have been interested in seeing that study pursued because we're not looking to essentially leave these institutions locked into 20th century technology capabilities with respect to preservation. But there, again, you'd be talking about first the question of preservation, and then secondly, preservation to what end? Simply the end of access to those works ultimately being what preservation is about. You would have to be able to determine whether, in fact, being able to circumvent in order to preserve those works is simply going to allow access by scholars and students, faculty, others who are using them for legitimate purposes, Or would the access policies subsequently threaten infringement in a way that might question whether or not circumvention needed to be more tightly cabined?
Thank you. Mr. Butler?
Oh, boy. Yeah, so I wanted to, I'll resist responding to Alan for a minute. I wanted to come back to something else briefly, which is another sort of risk in the question of whether the beneficiary of an exemption is going to actually get the benefit of the exemption. That's, I think, a relatively new risk is the question of whether the office will itself or will ask the proponents of an exemption to very narrowly tailor that exemption so that it steers far clear of any connection to trafficking. Because I think there are activities that we would say are clearly not trafficking. So, you know, again, internal assistance, right? So if an AV librarian is asked by a faculty member how to make a clip. I'm entitled to make a clip. How do I do it? What do I use? That's something that we think is not third-party assistance. It's not trafficking. It's all internal. If a documentary filmmaker has an AV staff person on the staff of that film, and the wording of the exemptions in the past, in the 2010 and in the 2012 iterations of the education exception, was nicely crafted, I think, actually, and this is, I think, probably on me and my students. We diverged from that crafting for reasons that are lost now to the mist of time, but there was a nice crafting that said sort of the person engaging in the circumvention would be allowed to circumvent for purposes of allowing educational uses by faculty and students. So that distinction between the person and the faculty made plenty of room in the plain text for a librarian. But that got tightened up this time around, and that may be on us. But I want to make sure that that is not something that, you know, is an outcome of this concern about trafficking, where it gets so tight that you can't have the AV person on your staff help you work on this.
Mr. Greenstein, did you want to follow up on this discussion as to whether, you know, activities on behalf of an owner authorized by should be something that the office can consider, and particularly Mr. Adler's point that it may be better considered by Congress, but also that Congress, in doing the Unlocking Act, was looking at whether it was implicating access to copyrighted works?
Yes, thank you. So the legislative history that Alan was reciting basically has a principle that is equally applicable to the situation that we're talking about. The reasoning is exactly the same. Allowing circumvention by an entity on behalf of the owner of an automobile does not create any risk of exercise of anything other than what's in the exemption. It does not put at risk the integrity of access controls or copy controls over other types of software. It is really integral to the particular exemption that's being granted. So similar to the rationale of, well, we want to make sure that when you unlock the cell phone, you're not unlocking all of the apps on the cell phone or other types of copyrighted works. It's exactly the same because the functionality is aspect of the what was at issue in the Unlocking Act is the same kind of functionality concern at issue with respect to automobiles. Similarly, you know, Mr. Adler tried to draw the distinction between services and devices, and at least in the automotive context, I don't think you can draw that distinction because there is no way that Click and Clack can provide a circumvention service for Toyota, Volvo, Ford, GM, et cetera. There's just no way that they can hire a hacking expert who understands the ins and outs and intricacies of all of that different software. And for some models, you know, up to 70 or more software modules in a particular automobile, and different for each and every model of automobile. There is no way that they can do that themselves. They need to rely on others who can create the tools that make that possible.
So you're saying there needs to be a market for software for circumvention in the aftermarket or auto repair?
Yes, and I'm intrigued by the suggestion that there might be some kind of, you know, authorization for locksmiths or something along those lines. I'm not sure that I agree with it, but I'm at least intrigued by the direction of that.
Well, which way does that cut, though? I mean, if we're, you know, if you can't separate services from devices, is there a concern that allowing services could incentivize the growth of a market, incentivize the development of tools, which I think some would be concerned couldn't be limited in their use to things covered by an exemption.
I don't think that concern exists for the particular market that we're concerned with, the automotive market, because the nature of the software is so particularized and particularized to each and every model of car that I don't think you have a generalized concern of a one-size-breaks-all. This is really a situation where a specific tool has to be provided for a specific piece of software for a particular part and function of a particular model of automobile.
So I want to ask one more follow-up about the auto industry and open it up and then get to Mr. Cooper-Schmidt, who has been patient. But, during the rulemaking, we heard a lot about the memorandums of understanding and sort of voluntary initiatives and partnerships. And Mr. Turnbull just suggested in audiovisual that, who he represents is open to voluntary initiatives. Is there some way to facilitate cooperation with the aftermarket that short of, upending 1201B?
I have very strong doubts that that is possible, which is why even despite the existence, look, if the Memorandum of Understanding solved this issue, the Auto Care Association would not be here on behalf of its 3,000 members. It does not address all of the issues, and the circumvention aspects, or the anti-circumvention tools are becoming more and more intricate and particularized each and every day, and often have absolutely nothing to do with the copyrighted work. For example, this particular software that's put in automobiles can be tied to the vehicle identification number of that vehicle. And that's purely for anti-competitive purposes. It has nothing to do with the copyrighted work or the expression or even the functionality. It's purely to protect the market. But yet there's no way to provide circumvention for that aspect of the car or the software alone without addressing the other aspects of circumvention.
Thank you. Mr. Perry, did you want to chime in on that question?
Right. Well, if you're playing devil's advocate, I don't think our client or Mr. Greenstein's constituents want sort of wild abandonment in the world of the aftermarket for automobiles. Nobody wants a safety hazard and trafficking of any kind of software or anti-circumvention device that's going to make it unsafe for any of us. But to suggest, if there's a suggestion, if you're on the side of the automobile manufacturers, if there's a suggestion that, well, it's available, you just have to come to us and we'll license it to you, I think that suggestion is kind of deceptive. It's not practical. I think the benefits of allowing, at least in this industry, the aftermarket to do what they have to do far outweigh the parade of horribles that could be attributed to it. I think I agree with what Mr. Greenstein is saying about, VIN-specific software. It's a very real issue. If you are in the bay, in your garage, and you find that the software for one Ford F-150 or GM is, for this car, and then there's a different one for that car. It makes it, from a practical standpoint, copyright and DRM has now impacted your ability to do what 25 years ago used to be done on a regular basis.
Thank you. Mr. Cooper-Schmidt?
Thank you. I hope you'll give me a little bit of leeway. A lot of questions have passed since
Yeah,
I
you can
put
take it back a little
trying
bit
to keep this
broader.
all on track. So I think kind of going in reverse order here, I have to admit I don't know that much about the auto industry, and I do know there's this sort of MOU we've been talking about, involuntary agreement. I don't know how that came about. I hear from you all that it doesn't do the job, but frankly, that's excuse me, one of the beauties of voluntary agreements is you can hopefully go back to the parties that you were able to bring to the table the first time and say, hey, this isn't working, can we come up with some mutually agreeable solutions and update it? That's a lot easier to do than sort of running to Congress, I think. Our concern, as I think Kevin mentioned a while ago, is, of course, once you've got these anti-trafficking tools are available in the marketplace, even if they're for ostensibly lawful purposes, they will inevitably become useful for law, or used for unlawful purposes and make them impossible to police. Now, we've heard that at least in the auto industry, no, it's sort of very specific. But then we've also heard, wait a minute, you can't do this dividing line between devices and services. They want the dividing line between functional and expressive, okay? And that becomes a concern because, where do you draw that line, right? Is Adobe Photoshop functional or expressive? What about TurboTax? What about iWatch, or the software on your iWatch? I mean, at the heart of it, all software is functional, at least to a degree, or at least I would hope it would be. And so sort of drawing that line, I think it's interesting and telling that, I participated in the embedded software roundtable on Wednesday, and we kind of separated these two issues, but it's clear they should not have been separated because, it was sort of taboo to talk about 1201 on Wednesday, and now we're talking probably more about embedded software, I think, today than we are specifically 1201 or the anti-trafficking provisions. Ultimately, I think we have to be really, really careful about where we draw the lines, how we draw the lines. I made this point on Wednesday. It could lead to a lot of inadvertent consequences. And in this particular instance, things seem to be, like I said, working quite well. I know that's not true across the board, but we have to be careful not to throw the baby out with the bathwater here. I think in terms of the auto industry, and maybe other industries, voluntary agreements and working sort of outside of Congress is a sort of probably a better approach, a better way to go about trying to solve this problem that we're hearing today.
Thank you, Mr. Scheffner. And I think, again, if you feel like we're talking about 1201 and if that implicates embedded software, feel free. We heard about the swear jar from Wednesday, but you can answer the question if it specifically implicates 1201.
All right, I'll try to be brief because Mr. Cooper-Schmidt actually just made several of the points that I intended to. But go back, I think, 2 or 3 questions ago about sort of whether the Copyright Office itself is authorized under the statute to create exceptions to the prohibitions on trafficking and anti-circumvention devices and services. And as Gene Bessick said a few minutes ago, I think the answer is clearly no. And I believe that the Copyright Office itself has acknowledged that in previous rulemakings. And I actually don't even think anybody here today has suggested that the Copyright Office on its own under the current statute can create those exemptions.
And so to be clear, you're taking the language of the Unlocking Act, for example, you think necessarily requires Congress?
Yeah, I mean, I think that's further, I think it was done that way in part because of an acknowledgement that the current statute does not permit the Copyright Office to do that on its own. And again, I don't believe anybody here has argued that the Copyright Office can create exemptions to the prohibitions on trafficking.
Do you agree with Mr. Adler that the Copyright there should not be a reform so that the Copyright Office could make the determination whether service on behalf of an owner might implicate copyrighted works? I mean, and I'm thinking, perhaps providing a way where there could be an evidentiary basis so the office could, for example, draw a line between circumventions for motion pictures versus auto repair.
We would agree with Mr. Adler that the time is not right to open up the statute. I mean, I think, look, there are legitimate policy arguments here, especially, by the auto repair people. I mean, I would point out we haven't heard from the other side on that issue, at least at this forum. So I don't think you should necessarily take as gospel everything you've heard on that without.
No, I mean, and obviously we've also looking at written comments.
Absolutely. But yes, this is, as Mr. Adler said, this is a major policy change that I think would require an act of Congress. Then, of course, once you open up the act, we're not just going to be talking about this one specific issue. I mean, there's lots of people have lots of different concerns, things they would like to change, not just about Section 1201, but of course other aspects of the DMCA it's impossible to confine it to that. And then just to quickly wrap up, I think you asked 1 or 2 questions ago about, well, what are the risks if we do permit exemptions for exemptions to the anti-trafficking provisions? I think we've touched on some of them before, but again, the basic problem is that even if you acknowledge that there might be legitimate reasons, or that there are people who have been granted exemptions to engage in circumvention and need a device or service or a piece of software to do what they want to do. The problem is that those, especially as to devices or pieces of software, obviously can't differentiate between the legitimate and the illegitimate uses, at least as to motion pictures. I mean, once you put it on the shelf at Walmart, yes, you might have people, Mr. Butler may be able, and his colleagues would use it for legitimate purposes under the, under the exemptions that they've been granted. But probably the vast majority of consumers would think, hey, here's a piece of software. It says that I can rip DVDs and Blu-ray players. That sounds kind of nifty. I should be able to do that. And it actually sort of it confuses consumers and misleads them into thinking that it's a legitimate activity where it's not.
I just wonder, though, where does that leave us? And is there any sort of proposal that you would suggest? I mean, just sort of anecdotally, at least, it would seem plausible to conclude that there is a material set of people who are beneficiaries of exemptions who, just as a practical matter, don't have the technical capability to circumvent. So I just wonder, are we stuck just without any sort of possible solution? I mean, I think one thing that we've suggested is, well, could we be granted authority to at least consider that as part of the rulemaking?
Well, I would say at least as to motion pictures and the exemptions that have been granted as to audiovisual works, I actually don't think there's a problem. I mean, I think Mr. Butler acknowledged, a few minutes ago, and I wrote down what he said. He said, quote, "We haven't been terribly deterred from engaging in the activity which is authorized by the exemptions that he and his colleagues have been
but
granted."
I mean, is he talking about prohibited activity or?
Well, I'm not saying that he's been engaged, or that, and I don't think, and frankly, by going
But I mean,
off,
I think that's the argument, right? I mean, that you're just sort of, encouraging people to, break the law.
Well, I don't believe that I've accused Mr. Butler of breaking the law. What I've acknowledged is the practical reality that he is able to go and find tools to do what he's been authorized to do by the Copyright Office, and that the other option, which is to say, okay, well, he's been granted the exemption, therefore there should be a lawful market in trafficking and anti-circumvention devices, has worse results, has worse consequences. I will say that the situation today isn't perfect, but the alternative of permitting, a legitimate market in circumvention devices or software would be much worse, and it would just mainstream that activity and, in a sense, swallow the rule against circumvention itself.
Okay. Thank you. Mr. Schwartz.
Well, just as a rhetorical question, I know you're here to ask questions, but if everybody agrees that the Copyright Office, the Register, and Librarian do not have the power to grant exemptions with respect to trafficking, then why worry about giving that appearance in the course of legitimately acting on a petition for exemption that is before you? To get to this point, as you did in the case of autos, you already need to conclude that this is a lawful activity that is being petitioned for. So why is it necessary, again rhetorically, is it necessary to look down the page to A2 and B1 and say, oh my gosh, if we grant this petition in the terms for which it's been petitioned for, so as to, however you phrase it, allow some expert assistance in the form of a service or somebody's aftermarket product or software. No court is going to say, because they can read the law too, that, oh my gosh, we're not going to allow this case against a trafficker to proceed under the DMCA because the Copyright Office granted an exemption to a user who had a lawful right. I mean, respectfully, I don't agree that the law should be interpreted to take that power away from the Copyright Office. The NTIA didn't think so. In its recommendations. At least our reading of the legislative history, when you read all the legislative history at the time that this was presented to the Congress, in terms of black boxes and for one purpose and not wanting to interfere with interoperability or the legitimate activities of retailers and servicers. So again, back to your question of what evidence is necessary. Once you've concluded that the activity is lawful and you've concluded that it doesn't involve copying of expressive content, if you still need to look for any evidence, if you're worried about trafficking, then look to those who oppose the exemption to provide such evidence. Otherwise, there should be a presumption under the power that you already have that it includes the right to expert help, just as it was silently assumed in the case of phones, or else nobody would have ever gotten the benefit of those exemptions.
Thank you.
So turning away a little bit from the rulemaking process, the Unlocking Technology Act is proposing to amend 1201A2 to tie trafficking to, rather than to circumvention specifically, but to facilitating infringement by circumvention. I was wondering if I could get your thoughts on that as an alternative.
Just, I know there were a couple of cards up. If you all wanted to respond to previous questions, I think feel free to do so while others can think about a response to the proposed legislation. So, Mr. Butler.
Sure. So just to sort of revise and extend my remarks from a minute ago, while Handbrake seems to work fairly well, a problem that we've seen, and a general problem that we've seen in all of these panels from beneficiaries is we don't know what we don't know about how much better these things could be, how harmed we are, what we can and can't do, because our behaviors are shaped by the law. So we have Handbrake. Handbrake does what Handbrake does. That seems to be great. We don't know what someone would do if Mr. Turnbull were to license them and they were to take full advantage, or if they were to get the benefit of an exemption. We don't know what the market would do in terms of generating better tools. We just got an exemption for Blu-ray, and Blu-ray's harder. And I'm actually looking forward, in a perverse way, I'm curious what will happen. Will people really get to use it? Because it is harder. It takes longer. It's a big file. There's sort of 2 or 3 different software processes involved in the ripping. So how will that work as easily as DVD? And then, of course, in the future, what's going to happen? And none of this stuff is going to be on the shelf at Walmart. And so if that's what we're worried about, let's open the floodgates for the specialized users, because they're not, mechanics don't shop at Walmart for the products that they need to rip cars. We don't shop at Walmart for the products that we need. The digital preservation librarian at UVA has this huge, bizarre computer tower thing that has all of these obsolete drives in it. It's a specialized tool. That's the kind of stuff that we buy, and we shop from people who sell that kind of stuff, and it's not Walmart. So that might be helpful. Maybe there's some consensus here. If we can keep it out of Walmart, it's all good.
Ms. Besic.
I just want to make a couple points. One is on the power of the Copyright Office to allow circumvention services or tools. I heard the quote from legislative history, but first of all, that was a statement on the floor, so I think we have to take that as that individual's view. And secondly, legislative history, one only resorts to if the statute isn't clear, and I think in this case the statute is fairly clear. So that's always the first place you go to understand the statute. The other point I want to make is about the functional versus expressive approach. I've been in copyright now for 30 years, and I really never thought I'd spend as much time talking about automobile repair as we have today. And I find it a little disconcerting. And I really would not want decisions about automobile repair and replacement parts to drive, no pun intended, the decisions about circumvention devices, circumvention services. And if that means ultimately there has to be some distinction between software that governs functional works, and then on the other hand, expressive works. And on that expressive works side, I would add anything that has to deal with any kind of playback device. Then maybe that's the route we have to go on. But if, I'm concerned that, there is a lot of understandable concern on the part of the public about not being able to get replacement parts for functional devices. And if that is going to affect the rules that govern, books on ebook readers and movies and all those kinds of things, then I think that we have to jettison some of those things or treat them separately, because I don't think that ultimately that copyright interests are going to win the hearts and minds of the American people on this.
Thank you. So we have a couple of placards up. If you care to respond to the question about the Unlocking Act, we would welcome that. Yes. The Unlocking Technology Act that's been proposed. Yeah. Mr. Love, did you have?
Yeah, sorry. The Unlocking Technology Act that was proposed ties circumvention in 1201A2 to facilitating infringement by circumvention. So I was just wondering what your opinions were on that.
I would agree with Professor Bessic's comment about not worried about like the automobile industry sort of driving the copyright thing. You could also turn that in its head, and you could sort of say, the rest of the economy maybe doesn't want the motion picture industry and the book industry to drive the rest of the economy either. I think that the marriage between these two things is I would agree, it is problematic. I go back to the idea in the act. I think it'd be good if you imagine at least two tiers of approaches. One for areas where you think maybe the whole regime is kind of intended for in the first instance, and where people feel comfortable that they're kind of working toward solutions in that area. And then a second area where kind of the collateral damage of the DMC, where automobile sector, medical devices, garage door openers, inkjet cartridges, all that sort of stuff. And that you begin the process of not treating everything exactly the same. In Europe, by the way, in the licensing issue that was brought up before, in Europe there's an obligation for copyright owners to take measures that make exceptions available to people. It isn't really clear what happens if they don't take those measures, but it's sort of, there is an affirmative obligation. I don't think there's any obligation like that in the US system, and I think that's a mistake. If you really want the automobile manufacturers to license people to compete against them and sell cheaper parts than the automobile manufacturer wants to charge themselves, and they have no obligation to do so, I don't really see why they would want to do that. And this idea that people within a sector should have to have an affirmative obligation to license the technology or the tools or whatever like that to address something as a first step. It also puts an obligation on people that are seeking to traffic in devices and things like that to pursue that opportunity before they resort to their own do-it-yourself kind of remedies as well. That may be kind of a compromise where you have a step where the people that are affected the most by it have to be approached, work out the basic details, understand kind of what the parameters of the debate are. And then if that fails, then you can sort of imagine kind of things moving on to like a different set of obligations. I just want to mention also in the licensing that in President Obama's books on Kindle, text-to-speech is turned off on almost all of them. And this is after like massive protest in front of the Authors Guild and tons of letters to the President of the United States from blind people, a fairly high-profile thing. And if you go on Amazon right now and check on President Obama's Kindle things, you will see that text-to-speech is turned off. So this is essentially a licensing error. It's a technical protection measure. This is either a switch that's either turned on or turned off by Amazon. Random House famously turns it off as a default position. And it just goes to the frustration people have when say, just call us up and we'll fix the problem. That doesn't really often work. And I think people have to recognize that that's not a very satisfying thing for consumers, just to sort of say that the people will fix it, particularly when you have devices where things have moved on, there's a lot of cost in fixing the problem, interoperability interfaces have changed, people talk about having refrigerators with blue screens of death because the software no longer works. I think you have to recognize that people just don't follow through and fix a lot of these problems.
Thank you. So we have just a couple minutes left, so I think this is going to be last call for comments, and if we can try to keep them brief. But I think since your comments, Mr. Love, involved Random House and Publishing, we'll call on Mr. Adler next. Thank you.
I just wanted to address the previous question, if I could quickly respond to Jamie. On the
I
issue,
think speak a little closer on the microphone.
Yeah. On the issue of an infringement nexus with access, we already discussed that in the first panel yesterday, so I won't repeat the comments I've made, just simply refer you back to them. But I would also point out that with respect to A2 and B, what Congress did was, 14 years before Congress enacted this statute, Sony decision by the Supreme Court had addressed the question of whether or not articles in commerce that could be used to infringe could be prohibited. And the court articulated a standard that talked about not wanting to see prohibition affecting articles that were could be used to infringe but were capable of substantial non-infringing uses. And most people spent the next 14 years and probably the time since then figuring out exactly what that meant. So what Congress did here in the anti-trafficking provisions was to try to be more specific about what the criteria were, and it's unquestioned that that criteria is in fact linked to infringing works. So I don't think there's any need for new legislation on that. And just quickly with respect to Jamie's comments about whether or not text-to-screen translation software or the read-aloud functionality in e-books is turned off, that turns out to be more a matter of individual competitive preference among publishers, and typically is a function of the way publishers negotiate agreements with authors. Usually it's if there is an audiobook that is also being authorized for publication by the author, they do not want the e-book to have the read-aloud functionality because they tend to think it competes with the audiobook. But again, that tends to be more of a contractual issue between the author and the publisher. It is not something that is done just as a matter of course, or particularly because of concern about violation specifically of a copyright right.
Thank you. Mr. Cooper-Schmidt?
Yeah, I'll be very, very brief. I just wanted to address comments Mr. Love made, not only just recently, but throughout, that sort of this law is being driven or is especially for the motion picture studios or the book publishing industry or the record labels or anything like that. And I can tell you that, we represent over 15,000, sort of small businesses and individual creators in this space. And they're very much supportive of the anti-trafficking provisions specifically. Do they sue or do they enforce the law? No, they don't have the capability of that. They don't even, oftentimes don't have the capability to actually bring infringement cases either. And matter of fact, that's exactly why they like this provision in the law, because otherwise they would be in this arms race just like everyone else. And that's an arms race that the individual creator is absolutely going to lose.
Thank you. Mr. Turnbull?
Just very quickly, first I wanted to associate myself with what Mr. Adler said about the Unlocking Technology Act. I won't repeat it, but I agree with that. Secondly, with regard to the language, going back a while in the discussion that was in the prior librarian-related exemptions, the DVD-CCA had agreed and accepted that language and would, again, and think that that would be within the scope of the Copyright Office's authority and would be appropriate in those kinds of exemptions. And similarly, the Copyright Office has, or the librarian in the exemptions that have been granted, conditioned certain of the exemptions on the use of certain kinds of screen capture software, either as a prerequisite to circumventing or, in a couple of cases, specifically as the method for allowing circumvention. And so I think there's precedent for that kind of thing, at least in very specific cases where there's been an adequate record developed and that sort of thing. And in terms of the sort of voluntary tool that I was talking about, it would be in that kind of vein that we would envision it being used as something that would be brought to the Copyright Office cooperatively, but would then be part of an exemption.
Okay, thank you. So Mr. Greenstein, next, last call, and I will say the next panel is about permanent exemptions, and I thought maybe I could also invite you to comment on whether in your particular situation for the auto industry, that might be sort of another workaround out of changing 1201B.
Okay, thank you. So first, with respect to the Unlocking Technology Act, it probably would solve the problems of our industry, but I think it's a much broader solution than is necessary. And in that respect, I note Professor Besic talked about how this is really kind of a separate issue. Well, that's why we sought an exemption, because it really is something that is an individual need, and I think best addressed in that way. And from that perspective, I think permanent exemptions are a positive solution, but merely adopting the current solution as a permanent exemption is not going to solve the problems of the aftermarket automobile repair industry.
Thank you. And Mr. Schwartz, I think you have the last word.
Yeah, just finally, I didn't mean to not comment on the Unlocking Technology Act. I believe CTA has supported that. Of course, as in case of any legislative consideration, we'd want to look at what's being proposed, exactly now and the most up-to-date formulation after discussion. But I think CTA is in support of it.
Thank you. Well, that will conclude this panel. We are supposed to start at 10:45, so that cuts the break short by about 10 minutes. I think we should be on track to just start that on time. Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.